Mr. Henkelvig, you may proceed.
May it please the court. Good afternoon. My name is Trent Henkelvig. I'm here on behalf of DeAndre Goode, arguing in support of an application for further review from a denial of an appeal from a post-conviction relief claim. Now, this specific denial of the appeal from the post-conviction relief claim was entered by the appellate court with the statement, or specifically because they said that there's no right to effective assistance of counsel at post-conviction within the Iowa Constitution. In doing so, the Iowa Court of Appeals used the citation from the Dunbar case, which says when they're looking at the federal Sixth Amendment context as far as effective assistance of counsel, it says essentially that there is no constitutional right to effective assistance of counsel in post-conviction actions simply because post-conviction relief is a statutory creation and not necessarily a constitutional creation. However, that kind of flies in the face of what Dunbar itself did. In Dunbar, they did come to that conclusion, but then they immediately turned around and said, however, at that point in time, it was Iowa Code Section 663 Alpha. Now it's Iowa Code Chapter 822. There's a statutory right to post-conviction relief, and within that statutory context, they allow for the appointment of counsel. And then in Dunbar, they went on to say that because counsel was appointed, it therefore implies the right to effective assistance of counsel. And by this implication, if the state wanted to make the argument that there was no right to effective assistance of counsel, that they then essentially had to make the argument that the assignment of counsel was, it lacked, or the assigning court abused discretion in applying for counsel.
But before Dunbar, didn't we squarely decide the question in the Furman v. State case and hold there's no constitutional right under the Iowa Constitution for post-conviction relief counsel?
Well, Your Honor, Furman was before Dunbar and it was before Pashat. And in those cases, I believe they were looking at the federal Constitution there. But if you look at Iowa Article 1, Section 10, it expressly states,
In Furman, they said we would construe our own Constitution likewise. So, I mean, we said it then.
Right. But what I'm saying, if we go back and think of the framers' intent, and so to do that, you got to put ourselves in the place of the Jeffersonian Democrats and the Whigs and the fledgling Republicans, and this argument over, you know, does the Iowa Territory become a free state or a slave state? And you know, it goes all the way back, you know, in our DNA, all the way to N. Ray Ralph, where when questioning these questions of can civil cases have an imprint on somebody's liberty and or life interest, and I think when you ask that question and you think of it in that context, it can. And then when you go back to Section 10, it says, in all criminal prosecutions and in cases involving the life or liberty of an individual, the accused shall have a right to, and then it lists the litany of rights, and you get to the last one, and it says, to have assistance of counsel, Your Honor. So
But if you look at that list, they all relate to trial, right? To confront witnesses, that sort of thing. And isn't the word accused important? That you're an accused up through your conviction and appeal. After that, you're...
an applicant.
Yeah.
That argument could be made, Your Honor, but I think if you look at post-Furman, if you look at whether it's Pachette, which Dunbar cited, or if you look at Dunbar, they're coming to this conclusion that although it's not necessarily a criminal prosecution, that the fact that a liberty interest is at stake, then there's a right to counsel, and there's a right to that counsel subsequently to be effective.
Let me interrupt you, though, just for a minute, if I may. And as I look at the record, we're on appeal here, obviously. And the claim, if I understand it right, for ineffective assistance of counsel relates primarily to a Facebook entry of some kind. I'm not even sure how to describe it, but it relates to some evidence that could have been made available at Facebook. That would have been helpful if counsel would have gathered it and offered it at trial. But of course, on appeal here, the record, we don't even know if in fact there was a Facebook entry. We don't know. I mean, maybe there was, and counsel made a strategic decision not to offer it. I mean, the record, frankly, is barren. And at this stage on appeal, it seems to me, you have not met effective assistance of counsel under federal or state constitution or state statutory requirements because you haven't shown prejudice. You haven't shown that there might have been a strategic decision. I mean, I don't know if the Facebook was dated or had a time that wasn't helpful. I mean, who knows? We don't know. So it seems to me, that regardless of underpinning, on the record here, you don't have an adequate claim.
Essentially, Your Honor, you're kind of in a way making the exact case that I'm arguing, is that this Facebook post was available. Even on the stand, Mr. Goode said, hey, not only were we there, there's a Facebook post out there.
We don't have it, I don't think. Tell me if I'm wrong. I mean,
it's not part of the record, and that's exactly my point. We're to the end, and that's why I asked for the very specific remedy of remand back to trial court and post-conviction.
Let me try and suggest another remedy I think you might have. You know, we decided this Allison case. I dissented, but it's out there. It's the law. And it strikes me the first PCR was timely filed. It was denied. You're claiming now that PCR counsel was ineffective for not introducing things that we don't have a record on, as Justice Apple pointed out. Now, if this appeal becomes final, it seems to me under Allison, you have the ability to go back and file another PCR if you do so promptly within the language of Allison. And then at that point, you can raise the statutory ineffective assistance in that. And we don't even need to get to any of the issues that this relating to this, whether there's a constitutional right to effective assistance of PCR counsel. Am I off base there?
No, Your Honor. I think if that's the decision the court would want to make, that would be an option that would be available to Mr. Goode to continue to try to pursue things.
Because it strikes me that given what Justice Apple says, and I agree with him, there's no way we can say that counsel was effective or ineffective based on this record. All we could do is preserve the claim for another PCR, and we don't call it preserving it, but we could just not rule on the issue. And then that would give you under Allison the option to potentially file another PCR on behalf of your client, or another lawyer to file another PCR. That's what I'm thinking. You see what I'm saying?
Yes, Your Honor, and that would be a route, but at this point, we're asking that it be remanded. In this case, so it would be allowed to develop a record on the initial PCR. I just think it gets harder for defendants as you get into, we've already been through jury trial. We've already been through appeal. There's been a post-conviction relief timely filed. There's been appeal on the post-conviction relief. And I just think, although the burden of proof as a technical construct, it basically remains the same, the perception changes when you're looking at a second post-conviction or a third post-conviction.
Normally you can't do that. Normally you can't on appeal say, my trial lawyer messed up, so I want to go back and remand for another trial or another hearing with a competent lawyer. Normally that's an independent standalone claim that has to be resolved on its merits without a remand, either by us on appeal if it can be resolved as a matter of law, or in a subsequent PCR proceeding, right?
Yes, Your Honor.
Well, let me follow up a little bit with that. You're here on further review seeking a right and enforcement of that right to an effective assistance of PCR counsel.
Yes, Your Honor.
And under Dunbar, it would seem that you have that right under the statute, and we've said in Dunbar that implies effective counsel. Why aren't you happy with the current right that you have under Dunbar to effective PCR counsel, and why are you concerned that it be derivative of the Constitution and not just a statute?
Well, Your Honor, the Court of Appeals acted on its own to come out. So the state didn't argue that there wasn't a right to effective assistance counsel post-conviction relief. The Court of Appeals on its own issued the opinion stating that there was no constitutional right. Therefore, they facially dismissed the appeal, Your Honor.
Well, but they said that you didn't raise your right to statutory effective counsel. You only raised it under the Constitution, and
That's
I'm
correct.
curious why that was the case.
Well, if you look at it, it's based, if you look at the case law, the right to effective assistance of counsel is based on the fact that there's a right to effective assistance of counsel in the Constitution. And then once that statute's there, and once that counsel's appointed, then at that point that right kicks in. So to kind of separate that out, it's like saying, well, this is October, and we're getting ready to harvest the corn, and we're going to put it in the bin, but the Farmer's Almanac says it's supposed to rain a lot in August, but it rained more in July and less in August. So we're not going to call it corn. It's still corn at the end of the day, and that's kind of like the difference between whether it's statutory authority or constitutional authority. The two of them have mixed, and you can't separate them out. So you could say, well, the seed was there, but the rain wasn't, or the rain was there, but the seed wasn't. Terminated, it's one thing at this point, Your Honor.
Well, we generally tend to refrain from applying the Constitution when it's not needed to resolve an issue that's been resolved by a statute. And I guess that's one of the doctrines that you're up against when you come and say, declare a constitutional right to PCR counsel under our Constitution.
Okay. Well, and this would go beyond just mere, at least in my interpretation of Article Article 1, Section 10, I believe it goes beyond just mere post-conviction. I think it goes to any action within which somebody is talking about a liberty interest. And this goes back to the very origination of the state of Iowa, when you know, civil cases very well could have been and were used in a myriad of different ways to limit throughout the country, to limit people's individual liberty status, Your Honor.
Thank you, Counsel.
Thank you, Your Honor.
Ms. Chambers.
May it please the court, my name is Bridget Chambers. I'm from the State Attorney General's office, and I'm here representing the state. The court should decline in this case to reach the issue of whether the Iowa Constitution provides a right to effective counsel in collateral proceedings, such as proceedings under Chapter 822. That issue was not raised in Goode's initial appellate brief. It wasn't raised by the state. Neither party discussed it. And it was, I think the Court of Appeals actually misread Mr. Goode's brief in finding that he was trying to raise a constitutional claim. As some of the court's questions have suggested, this case can be decided under strictly the regular Strickland prejudice, cause and prejudice standard, and there's no need to reach the constitutional claim. Even if that were not the case, this is simply not the right case to reach the constitutional issue. That issue should be reached, if at all, in a case where it has been fully litigated, which this is not that case. If the court should choose to reach the issue of whether there's a right to effective counsel in collateral proceedings under the Iowa Constitution, then it's the state's strong position that that issue is resolved not under Article 1, Section 10, but under Article 1, Section 13, the habeas clause. The habeas clause does not provide any right to counsel by its language. No decision of this court or of the federal Supreme Court has ever found a right to effective assistance of counsel in a habeas proceeding. And the vast majority of the states that have considered that issue have found no constitutional right to counsel in a habeas proceeding. Chapter 822 implements the Iowa habeas clause, and as such, there is no right to counsel under the Iowa Constitution in Chapter 822. Any right to counsel arises from the statute.
Should we
Well,
assume that there's a statutory claim here, a statutory claim for right to counsel? I mean, it's a little, the procedure here is, shall I say, irregular. It's a somewhat an odd posture, because you have the Court of Appeals, it seems to me, kind of reaching out, deciding a constitutional issue. We have pleadings that brush by. I mean, they talk about right to counsel. I mean, they're not very specific. But is there enough there to say it's a statutory right to counsel, which is well established? I mean, is properly before us?
Yes. In fact, we almost never talk about the statutory right to counsel and ineffective assistance claims anymore, because it's been the law for so long that any right to counsel is statutory. And that statutory right then incorporates the constitutional rule, Strickland and its progeny. So it is absolutely normal, routine. It would be an exception, in fact, at this point, for appellants to specifically say, I'm talking about the statute here. And seldom, if ever, does the state even say that in our responsive brief. Maybe occasionally if it's somebody we feel like doesn't maybe know that, but generally not.
Was my description of the record accurate? I always like to test that a little bit, but it seems to me that you had some testimony, but I mean, thin.
Right.
And Justice Mansfield was suggesting, I think, and I was suggesting that probably on both prongs, it's of Strickland. It's a little hard to tell where we are exactly.
Right. The state strongly believes that there's been neither a demonstration of breach of duty nor resulting prejudice.
Was there anything else in the record besides the snippets that I've talked about that might arguably give us a little more grist?
No. At trial, the defendant kind of vaguely testified. He testified that he was home with his girlfriend, and his girlfriend also testified that he was home. And then the defendant made sort of a vague reference to, you know, I was making some postings on Facebook. He didn't even say what time he did that. I mean, I think it was kind of everybody inferred from him bringing it up that it was probably at the time of the burglary or robbery, since he was raising an alibi
It
defense.
could be the council did investigate and found him and thought, oh my heavens, this doesn't help. I mean, it could be, I
In
guess.
fact, frankly, I think that's the most reasonable explanation.
We don't know, bottom line.
I mean, if a Facebook post can be made by anyone from anywhere using my phone, I could make it look like I'm in the Bahamas right now, but I'm not. So I suspect that is why council didn't raise it, but we don't know on this record.
I mean, Ms. Chambers, I'll say, kind of reading the briefing, I'm not overwhelmingly impressed with the argument that this Facebook post, if it existed, would have made a difference. But wouldn't the safest thing to do be just to affirm the denial of PCR with some indication, perhaps if necessary, that Mr. Goode can go back and file a second PCR under Allison if he actually has the Facebook post, and then they can litigate down there whether that's a proper PCR and whether there was ineffective assistance and whether that would have made a difference?
Yes, that's exactly the right remedy.
Let me just follow up then with a question about the statutory right. If there is a statutory right to effective counsel, as Dunbar, in a PCR, as Dunbar indicates, would the constitutional enforcement is sought in this case, would the due process clause support the imposition of effective counsel in those cases where the statute requires counsel?
No.
Why not?
In the Coleman case discussed in this court's Allison decision, the court talks about that particular claim and says there is no due process right to counsel after the first appeal as of right, and discusses Ross v. Moffitt.
No, my question is if there is a constitutional right to counsel, would the due process clause require that counsel that this government would appoint to satisfy that right need to be effective?
No, because under Coleman and Ross versus Moffitt, there's no right to counsel after the first appeal as of right. And if there's no right to counsel, there's no right to effective assistance of counsel. And those cases were specifically decided under the due process clause. Granted, it was the federal due process clause, but we have not interpreted our state due process clause differently. If there are no other questions, the state will stand on its brief. Thank you.
Thank you, Ms. Chambers. Rebuttal?
Well, first of all, the question of due process, I think, again, those questions were addressed in Coleman, and it was federal and not state. As far as the record of the Facebook post, I mean, the testimony said that it was GPS, an app that had a GPS timestamp. So if that were to be found, it would, in fact, I think, be a silver bullet. It's very seldom do we have a silver bullet type of evidentiary case, but in this case specifically, we had 4 days worth of evidence and really only about a half a day's of evidence on the robbery that took place. So on November 25th, there was a robbery where Mr. Peachtree he'd gone to the grocery store to get some food for his pregnant wife. And he came back and was assaulted by 3 men. And he said that the only visual he had was of somebody in the process of swinging at him, punching him for a split second at night when it's dark, and then only got an ID of Mr. Goode after the second six-pack, within which the first six-pack that the officers brought to him, he wasn't identified. The second six-pack, where both him and Mr. Ham were there, he was identified. So I think this alibi, although it was impeached quite significantly, because it wasn't necessarily the girlfriend that Mr. Goode was with. It was a friend of his baby's mama who he was trying to get back together with, who...
There. I can't get beyond that silver bullet thing. I've never thought of Facebook as a silver bullet for anything. But wouldn't it be reasonable to assume that maybe you can get that geographic data, GPS, but there's going to be a whole heck of a lot of other stuff on that Facebook? Wouldn't it be reasonable that it's perhaps an attorney's strategy to not let a little bit of Facebook in for fear of all of Facebook getting in?
It would be reasonable. That's very possible, Your Honor. And I think that if the record would probably show that at trial, the phone would have been brought to trial counsel, and he said, no, we're not giving the state your phone. I believe that would show. That's not in the record, but I believe that would in fact come up, Your Honor. But I think given the fact that this robbery happened on November 25th, and there wasn't anything even putting Mr. Goode's address into question until December 10th, at a time when a credit card was applied for out of the wallet from this, and that credit card that was applied for was in somebody else's name at a Megan Smith's address with where a Mr. Ham primarily lived, who was DeAndre's Goode's roommate. But the other 3.5 days of evidence were all about this identity theft portion, to which Mr. Ham was significantly the perpetrator of. But there's 2 weeks in between this time frame when the credit cards and bank information is in Mr. Ham's possession and the robbery. So I think an alibi in this case is much more significant, even if it's not the exact same time as the robbery itself, Your Honor.
Thank you, Mr. Henkelvig.
Thank you.
The case of Goode versus State is now then submitted, and the bailiff may adjourn.
Thank you, Your Honor.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.